And Foltz was that rarest of women, a courtroom lawyer. They were among the dozen or so well-known women lawyers of their day. There were about, in the 1890 census, there were something over 200 women lawyers in the whole country, a tremendous increase in a decade from the 75 in the whole country in 1870. Foltz's topic was also arresting. It was titled Public Defenders. Now compare that with the subjects of some of the famous male presenters. Thomas Cooley spoke on civil justice in America. John Henry Wigmore on civil justice in Japan. David Dudley Field on the codification of American law. And the most famous of all was James Bradley Thayer of Harvard, who urged judicial restraint in passing on the constitutionality of legislation. Probably, maybe the most famous constitutional law article in history. But the Mary Green subject was on married women's property rights, and it fit the program. It was a suitable, even ladylike topic, written and delivered at a level of abstraction that matched the men's presentations. Now, Clara Foltz, on the other hand, gave an old-fashioned barn burner of a speech, featuring drama and pathos as well as solid legal analysis. Her speech came on the second day of a three-day Congress in which her voice was the first woman's voice that was heard, and in which there was no effort to make the papers interesting or lively. That wasn't the style of this Congress. So her speech caused a sensation. She started with a classic opening taught by rhetoricians and called an exordium. She said, "If we were to inquire of wisdom through her sages and statesmen, of morality through her poets and preachers, of sympathy through our orators and actors, what were the duties of the state toward those accused of crime? They would unite with a common voice in declaring that the citizens of a state are far more vitally interested in saving an innocent man from unmerited punishment than in the conviction of a guilty one." Then Foltz turned immediately to the central question of criminal defense. How do we distinguish the innocent from the guilty? Her answer, we don't. Until the jury verdict, everyone is presumed innocent and should be so treated. Not only, she said, because of the legal maxim, but because in over one half of the cases, basing it on her practice in San Francisco, the accused is actually innocent. And she felt, based on her own experience, that the presumably innocent must be treated the same way as the factually innocent by the legal system. Based on this rights-based presumption of innocence as an individual right to be carried out was also an original idea, almost as original when she brought it up as her idea of the public defender. Based on her own experience, Foltz also spoke of prosecutorial misconduct and something no one did, of police perjury. Both the prosecutor and the police, she told her audience, mistakenly believe that it is the duty of the state to convict whoever is arrested. Foltz opened her attack on the prosecutor by picturing the ideal, a powerful male figure, strong of physique, alert of mind, learned in the law, experienced in practice, and ready of speech. He was once, this prosecutor, a minister of public justice, aiding the court in a solemn investigation of crime, laying bare the truth wherever it may lead. Having set him up in this way, Clara Foltz, a preacher's daughter, made a gripping sermon of his fall. It was a tale of power corrupting. He has fallen to the vanity of winning cases and the lust for gold. He has turned into an indiscriminate public persecutor whose motives were mainly his own interest, vanity, avarice, and fear. Gone was that free and impartial investigation which was the pride and boast of the English law. And then, verbatim from her Wells brief, she added, around and behind the prosecutor is an army of police officers and detectives ready to do his bidding, and before him sits a plastic judge with a large discretion, often affected by newspapers. Having pictured all the force arrayed against the accused, Foltz rhetorically asked, what machinery is provided to defend the innocent? And answered, none. Very dramatically, none at all. And finally, she spoke of the right to counsel, enacted in the federal Constitution, reenacted in almost every state, which guarantees to the accused certain rights, she said. He may have a speedy trial, he may have a trial by jury, he may meet the witnesses, he may have witnesses in his behalf, and he may have counsel for his defense. These are great constitutional rights guaranteed to every citizen. They are unconditional, and it is a grave question whether Congress or the legislature may add to them a condition if the accused can pay for these rights, a condition that renders the guarantee inoperative. The right of counsel for the defense, guaranteed by the same Constitution in the same section, couched in the same language, and subject to the same rules of interpretation as all these other rights, must carry the same weight, which means, she said, that the accused is entitled to defense, and that this defense shall be full, adequate, and free. Free justice was her motto. She argued this more than 70 years before Gideon. Foltz's learned audience was surely amazed because they were a long way from what was happening in the baseline criminal courts by this time. To hear a woman speak on topics so apparently removed from either feminist causes or the usual stuff of scholarly debate and concern. Not only the subject itself, but the frankness of her language must have been unsettling. Her repeated uses of words like vicious and malicious when speaking of prosecutors, and her reference to a plastic judge, to say nothing of her discussion of police perjury. Having painted the scene plainly and harshly, Clara Foltz then offered her solution. And one of you, Addison Steele, told me he once copied these words and held them up in front of the jury. And I think you won the case, didn't you? Where is Addison? Right there. Yeah. You don't remember? Yes. Oh, good. Yeah.
That's a good
Here
story.
are words. For every public prosecutor, there should be a public defender, chosen in the same way and paid out of the same fund as the public prosecutor. Police and sheriffs should be equally at his command, and the public treasury should be equally open to meet the legitimate expenses. This powerful figure, on a par with the public prosecutor, would produce immediate benefits, she said. Her description of the inadequacies of appointed counsel revealed Foltz's expectations for the public defender, and indeed for all defense lawyers. They should investigate every case. They should prepare the law. They should summon witnesses. They should advise their client on his plea and use all ethical means to achieve the most favorable verdict at trial. She lauded the skills of the good lawyer and found it unfair to compel credit to a pauper for the use of these skills. With the public defender, she promised, malicious prosecution would cease. The accused would have a free and adequate defense. Courts would be freed from the squabbles that now disgrace them, and the profession would be relieved from rendering compulsory free services. Let the criminal courts be reorganized upon a basis of exact, equal, and free justice. Let our country be broad and generous enough to make the law a shield as well as a sword. And then she promised for the people the blessings which flow from constitutional obligations constitutionally kept and government duties sacredly performed. That promise holds true today. Thank you. That really touches me. I haven't had a standing O for a long time. It makes me feel very good. And there's no one I'd rather have one from. So thank you.